Good afternoon. Good afternoon, Nikivia. Please correct
Afternoon,
my
sir.
please correct my pronunciation of your name if I'm wrong.
Yes, it's Nikivia.
Nikivia. Okay, I will. No promises that I won't screw that up again, but keep correcting me, and I'm going to keep working on it. Nikivia. All right, so we're a little shorthanded today. Um, it happens. These things go on. We'll see if folks straggle in over the course of the next few minutes. But if not, then you and I'll have a quick conversation. We'll make sure that you're squared away, and then we'll call it a day. And here's somebody else. So again, we'll go as long as we go, and we'll, if we wrap up early, we wrap up early. So first thing that I want to do is I want to check in with you guys and um, see what you feel like you learned last week in the lectures, so that we can make sure that everything's clear. And if you have anything that you don't feel comfortable with, we can visit it and talk about it. Yes, Naomi.
Hi, good afternoon.
Hi.
So I just want to say that I think, okay, this is tutorial 5, which was originally scheduled for Wednesday at 12.
I think that's right. At this point, I don't know what they've done. The truth of the matter is that um, uh, the banner unit has made a giant hash of the schedule this semester. I think that this is supposed to be tutorial 5.
Okay, so my thing is I'm in tutorial 7, which whose original time was at
Right
Friday
now.
2, yeah. So when I saw that, I just said, okay, I'm just gonna stay here. But then I realized it meant that I jumped tutorial group. So I jumped from 7 to 5
Yeah.
because I didn't like the time that 7 was 4. So
Right.
is that okay?
This week, absolutely. But starting next week, you will have to attend the tutorial that you are enrolled in. So if you want to keep this time slot, you'll need to disenroll out of tutorial 7 and enroll in tutorial 5 if there are seats available. And I don't know what the answer, whether there are or not.
And then this week, okay, so tutorial 7's correct time is Thursday at 8 a.m. And then this Thursday we actually had a 2-hour lecture, so I didn't get to attend my time slot. I don't know if you realize that. I don't know if students attended tutorial on Thursday at 8, but we had
no one did. That was a
I didn't realize that until after, else I would have like sent you an email.
Mhm.
But it's the same day I realized. I said, oh God, we have
Other people are trying to get in. Sorry for cutting you off.
They are not in the waiting room, so they're
they
probably in the
probably went
wrong.
to the other link. They probably went to the tutorial 7. So you have to tell them to pick tutorial 5, which is Wednesday at 12.
Oh, that's right, because I have not. I updated everything else and didn't update the links page. That's my fault. But yes, Naomi's absolutely correct that that's what folks need to do. So thank you for passing that along. Um, okay. So yes, the answer to your question is if there are seats in tutorial 5, which I think there are, but I don't know.
Good afternoon.
Good afternoon.
I think we're here. I was trying to get in using another link, but couldn't.
It happens. It's not a big deal. That I have. The matter has been brought to my attention. I know what needs to be done to fix it. I will fix it after this tutorial. But what I was saying to Naomi, who was asking about keeping this time slot and switching into this tutorial that moved to this time slot, was that's fine. You're welcome to do that if there are seats available. If there are not seats available, the faculty is pretty insistent that we minimize the use of overrides. So what I told people in the email where I announced the schedule, and I sort of stand by that now, is I understand that the timetabling unit scrambling things in the second week of the semester or the third week of the semester has could create problems for you. You may now be enrolled in classes in times that are not convenient for you for any number of reasons. And so you're more than welcome to move around into tutorials that have open seats. Overrides are generally disfavored, and so I would need a fairly convincing argument as to why you needed the override. And I can tell you that a student has already asked me for an override on the basis of this time slot isn't convenient for me, and I told them no. So that's not an argument that will fly for you. Okay. Any other administrative stuff before we get into the matters of the class, of the tutorial? Okay, then moving on. So the first thing that I want to talk about is I want to check in with you and see what you guys learned last week in the lectures. So just let me know what you feel like you took away from the lectures, and then if there's anything in particular that you don't feel like you have a grasp on, let's talk about it now. So I have a private message, and the way that I handle private messages is if it's something that the rest of the class doesn't need to know, I'll respond to you in chat. If it's something that we need to discuss as a class, I will discuss it with the class, but I won't out you. So I will say, this is what I was asked, but I won't say who you are. Okay, so the private message says, could you explain psychiatric injury? Don't quite think I get the concept of it. So the idea is, I think the way that I would describe psychiatric injury is to think of it like this, right? How do you prove physical injury? You show medical records, you demonstrate the cost of treatment, you show other knock-on effects such as like lost wages or lost earning capacity or those kinds of things, right? That are tied to the physical injury, right? Psychiatric injury works the same way, but it refers to harm done to your mental health. So you come in, you show the medical records, from the mental health professionals, you have testimony from the treating psychologist or psychiatrist or whatever, right? And those are the things that matter. And the fact of the matter is that these boundaries get fuzzy, right? So Naomi says that psychiatric injuries must be medically recognized, such as PTSD, personality disorder, trauma-induced miscarriage, not just regular stress or grief. That is not my understanding of psychiatric injury. However, my understanding is very strongly informed by my American background. And so I could be wrong about that. But what I'm going to say here is that the boundaries of damages are fuzzy. Okay, it is not always clean and clear whether damages fall into a physical injury or a psychiatric injury or what's sometimes referred to as non-economic damages, or sometimes called pain and suffering, right? Those kinds of those categories of damages. And the lines between those three categories are not always clear. And so it is entirely possible that the jurisdictions that I am familiar with and the things that I've read about the Caribbean don't close off for the possibility that Naomi is correct. Okay. So the answer to so I think that Naomi is absolutely right that medically recognized psychiatric injuries are absolutely recoverable, and you prove them the same way you prove physical injuries. For things like stress or grief or those types of injuries, you may wind up proving them using the proof system that you would use for pain and suffering damages. Okay, but I would argue that they're still recoverable, but they may not be recoverable using the same method. Okay, so does that? I hope that clears things up. You know, I'm working as hard as I can to sort of get up to speed on regional law, and certainly that's my focus on teaching you guys. But when you offer something up that I don't know the answer to, I'm going to give you the best answer I've got, which is based on what I already know. So I have a private message. Should physical injury be present with emotional injuries? That's a great question. The answer to that is I think sometimes yes. Let me double check in the book, make sure that I'm not out of my mind. So special damages, blah, blah, blah. Da, 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 da. Heads of general damage, pain, suffering, loss of future earnings, loss of earning capacity, inflation. So the answer to your question is I'm not sure whether there must be physical injury for recovery for psychiatric damages. I'm not seeing anything on anything specific on the in the damages chapter. And just to double check, yeah, there's nothing in the first chapter either. So the answer is that my experience is that in negligence, which is what we're talking about now, recovery for emotional injuries or psychiatric injuries does require some sort of physical harm. It can be the physical harm can be very de minimis, right? You can have $1 of damages of physical harm and $1 million of damages of psychiatric harm. But you do have to have that physical harm present. For intentional, for IIED, right? Intentional infliction of emotional distress, which we're not going to talk about here. There's no requirement for physical damage. a private message, doesn't the answer depend on whether the victim is a primary victim or secondary victim? So that is also consistent with my experience, that if the physical harm is to the actual plaintiff, then here endeth the inquiry, right? The physical harm can, then there's the answer. If the emotional damage is from witnessing physical harm to someone else, so basically like I'm walking down the street with with a companion, and a car comes off the road and hits my companion but not me, right? I can recover if my companion and I had a special relationship, and that there are defined categories, right? Spouses, parents, children, sometimes siblings, right? If it's just my friend, then no, I have to have suffered the physical harm. So so there has to be physical harm involved for negligent emotional injuries, but it either has to be to the plaintiff themselves or to someone that the plaintiff is in a particular relationship with. Okay. So getting a couple of private messages that suggest that the psychiatric injuries that Naomi mentioned, the definition of psychiatric injury that Naomi mentioned is correct in the Caribbean. I don't have any reason to disagree with that. So, okay. But this is getting a little far afield from what we are supposed to be doing right now, which is, what did you learn last week?
Sorry, are you referring, are you within the ambit of the question, the total question?
No, we're
Go
going to
ahead.
get to the
Okay.
tutorial question in a minute, but this
Okay.
is what did you learn last week? You did not learn res ipsa loquitur last week.
No.
No,
Did-
sorry,
did-
that's a message that I got in chat. Or don't worry about
okay.
it. Yeah. So yeah, last week. The purpose of this is to check in with you guys and make sure that you understood the material that we covered last week. And so this is why I'm asking this. I'm not just, doing this for my own amusement.
Sir?
Yes, go ahead.
Hi, so this is with reference to the test that you were discussing last week.
Okay.
I just wanted you to be able to go through it again because I wasn't able to fully like distinguish between what is the main difference between the proximity that's stipulated in terms of like physical. Is it only like physical closeness, like having to do with physical?
Yeah, the answer is almost certainly not, right? Especially not in the modern world. If proximity requires physical closeness, then in the world of the internet, defamation ceases to exist, right? So I think the issue of proximity becomes odd and fuzzy when we start to ask the question of what we are talking of what it means in the modern world. So a private message, and look, I'm not going to out this person, but you're offering really good information, and there's no reason for you to continue private messaging me. You should be putting this into the chat for the entire class. Okay. If you're nervous about it and you want to keep private messaging me, that's fine, but I promise you're doing fine. Okay. So I've got a private message here that asks if I'm asking about the Caparo test. Certainly the Caparo test is one of the things that we talked about last week, right? Look, when I ask, what did you learn last week? Your answers should not be questions, right? The answer to that should be declaratory statements. Did you learn the Caparo test? I don't know. Did you? I certainly tried to teach it. So, you know, I promise I'm not upset over this. I'm just saying you guys are great. And you're smart and you got this. And Naomi's absolutely right that it's totally okay to ask questions. Okay. But answers to the questions, answers to my questions, like, should be statements, right? You should feel confident in what you are saying because you're probably right. You guys are smart. All right. So so 1 second. Let me take care of this. All right. So more broadly, right? Beyond the Caparo test, what were you learning last week? Colette says the elements of the duty of care, and that's absolutely right, right? So what questions do you guys have about the duty of care? And specifically, right, we were learning about how courts go about identifying a new duty of care, right? Because remember, one of the things that the courts keep saying is that if we've already identified that a duty of care exists, we don't have to reinvent the wheel. We can just go see this precedent, right? So you guys feel comfortable with the duty of care test, or are there things that you're not clear on?
Excuse me, is the Caparo test like the test used today?
Boy, that's a great question. And I here's what I can tell you. Okay. The Caparo test is the most recent test in the Codolini book. However, all of these tests are, right, the Donahue test, the Ann's test, the Caparo test, these are all English tests, right? These are all English tests. And English law has evolved beyond Caparo, but it's done so since Professor Codolini's last revision of the text. And so this was why when we had our lectures last week, we talked about the Robinson test, we talked about the Poole-Borough test, and we talked about the Toombs case, all of which are available. The Toombs case is on e-learning, and the worksheet has some stuff on Robinson and Poole-Borough. So I don't have a solid answer for you as to whether Caribbean jurisdictions are going to continue to follow the evolution of the doctrine beyond the Caparo test. I think some of that will depend on what Professor Codolini does the next time he revises his book, because obviously these books are very influential in the region, this whole series of books. from Rutledge. So if he incorporates the Robinson test into his book, then I think that we'll start to see local jurists start to use it. And just so we're clear, right, the only difference between the Caparo test and the Robinson test is the Robinson court says, hey, we're not okay with you using the Caparo test sort of as this freestanding mechanism. You have to begin by looking at prior precedent, and you have to reason from the analogies of prior precedent. And you can only go on to sort of independently and analyzing the duty through the Caparo test if prior precedent doesn't give you an answer. Okay. So that what had happened was that the lower courts had used the Caparo test as a checklist, and they were using it in lieu of analyzing precedent. And the Robinson court says, no, you can't do that. So, Naomi, does that answer your question?
Yes, it does.
Okay. I apologize that it's not more certain for you. I think one of the things that is actually very helpful for law students is to see and embrace and understand that the law is actually very uncertain and contingent. Like a lot of times the answer to a question is, boy, I don't know. I guess we'll find out when a judge actually has to decide it. But until then, these are sort of the options that we have. And Colette has correctly placed the Caparo test has correctly stated the Caparo test. So thank you for that. Okay. So before we move on, any last questions on this? Okay, we're gonna move on. Before we do, I tried to be private about it, but I'm gonna call you out. Whoever is in here with the display name of the HR boss, no, you need to fix that. So if you don't, I will throw you out. I need to know who you are. Okay, so check your display names. Jamila.
Sorry, my personal laptop died, so I'm using my work laptop. Sorry, that's why I signed on and came back in.
It's no problem. I was just, I needed to know who you were. So thanks for
That's
fixing
okay,
that.
sir. You don't have to take me to court. I'm sorry.
So,
sir, my
yes.
My first name is Lingwei, and I know Patterson. You're saying Patterson, right?
Yes.
Right. So Patterson and Lingwei are the same. My first name is Lingwei, so I'm using my desktop. My desktop
Okay.
reflect. Yeah.
Okay. Well, I'm, if you don't mention something like that, right, I'm going to call you by the name that you're that is on my screen. So, and I will, even if you do correct me, I will probably forget and call you by the name that's on my screen. So
that's okay.
So okay. With that, let's move on to the tutorial question that's on e-learning, and just so that we understand, you guys were asked to think about and prepare arguments for both sides of a proposition. And there's the proposition in the chat: contract and criminal liability sufficiently deter negligent conduct without the need for independent causes of action in tort. Okay. So I want to start by hearing your arguments for the proposition. And I want to start there because I feel like that's the harder side to take. That's the movement away from the status quo. And so I want to encourage you. I want to offer that up, even if you guys think even if you think that your arguments against are stronger, right? I want to hear from the four first. Go ahead, Colleen.
Hi, good afternoon, everyone. Sarah, where did you post that question? Because I'm not seeing that question. So I thought,
Sure.
It would be the worksheet questions that we were doing.
Sure. So certainly I will draw from the worksheet questions where, I like them. But if you go on to e-learning, and there it is. If you go on to e-learning and you look in the weeks block, you'll see that there are tutorial questions, right? And that's where what we're actually going to discuss in the tutorial will be posted for each week. Okay, so that's what.
Okay, thank you.
Yep, not a problem. Oh, I have neglected to post next week's worksheet. I need to do that. All right.
Sir.
Yes, go ahead, Leonard.
Right. I just want. Can I tell you can I just read to you how I introduce this thing?
Sure.
Because and then I can. You tell me if I'm attacking this correct or wrong. I said I strongly disagree with the statement. That's how it began. And I said this is primarily on the grounds. My mic is not too loud. You're not hearing?
No, you're fine.
Oh, okay. That it is primarily on the grounds that both criminal and contractual liability can only secure redress within certain perimeters of the reach of the law. All right? And they cannot fully suffice redress for negligent conduct. Am I answering correctly? Yeah.
Okay. So so let me stop you right here because what I wanted to start with was arguments in favor of the proposition. So what did you come up with in favor of the proposition? Because you were told to prepare both sides.
Let me tell you. In terms of my stance, I strongly.
I get what your stance is. What your stance is. As lawyers, you will very frequently have to argue a case in which you do not believe.
Right.
And so you were tasked with preparing both sides of this argument because you will at some point be asked to do that as an attorney. So my question to you is, that's fine. I understand that you don't agree with the statement. What's the best argument that you're able to muster on its behalf?
Okay, tort law can be generally incorporated into all rights which are fundamental. That's that's because of a special morality I see being generated in tort law. For instance, and a person who's in prison, even though there is for a criminal wrong, they could have been held wrongfully, and the tort of false imprisonment is there, or the aim of it is protecting that person from the arbitrary arrest or detention, from arbitrary arrest or detention, and whereas criminal law may criminal law may provide too many loopholes and anomalies, which because of inadequacies. Tort law is about corrective justice. Am I on the right path, sir?
I mean, let's hear from your classmates. What do you guys think about Lennox's arguments? What do you think? What do you guys think?
I'm not sure if he's answering the question. I don't really understand. Okay.
To be perfectly honest, I think I agree. Lenrick, I think that the question is asking, let's assume, and this may not have been clear, right? Let's assume that we're doing away with tort law. If you have a tort claim, the only way you can bring it is if you can bring it as a contract claim or if a criminal prosecution can be brought. And the question that you are being asked to answer is, does this system deter negligence sufficiently?
So can I try?
Go ahead.
Just
Let-
before
let
we go,
Let me. We gotta move. We gotta move on, Lenrick.
I
gotta
just
move on.
wanted to.
We gotta
just
move
want-
on. Sasha, go ahead.
Right. First, I looked at what it mean by contract and criminal liability. And I'll say that both carry heavier penalties or punishment than tort. With contract remedies, the remedies to put the claimant into the position he or she would have been, had been prior the contract had been performed as agreed. I would say that because of the associated penalties, one may be driven to be more mindful of their actions or omissions, and therefore mindful of their duty of care and make a conscious effort to avoid breach of that duty and possible resulting harm. On the contrary, if you want me to go on,
Lay it on me. Finish your thought.
said negligence is inadvertently taking an unjustifiable risk without realizing the risk taken. Therefore, based on the fact that there is an absence of requisite mens rea, intent, one cannot be deterred from doing something they had no intention of doing. Similarly, if the contract was accidental, intent would be missing. I also said that even if intent was missing, as long as the person had a duty of care, they can be convicted of gross criminal negligence. And you see that in RV Pitwood, where there was a contractual duty, and RV Datum and RV Miller, and even RV Instan. That's it for me for right now.
I think that's fantastic. I think that, and I want to be clear that the key piece of this is to get you thinking about this. I'm not especially concerned with what your answers are, right? The idea is that engaging with this and thinking about the material is the right answer, regardless of sort of the substance of what you say. So what do we have for the against side, for the other side of the debate? So what were you guys able to come up with there?
Sir?
Yes, go ahead, Kayla.
It's basically kind of on the first point that was made by, I think her name is Sasha. She mentioned the fact that contract and criminal law basically have heavier penalties. And in that instance, I think is not really, in my opinion, it's not really fair to criminalize someone based off of an action that was done without any harmful intention. So that's why I kind of see tort as something that's necessary in cases where the the physical harm was not intended. However, it did actually cause a major consequence of the actions that were actually conducted, but it does not carry with it the idea of being a criminal or purposely going out to do that action to harm another individual. So that was the point that I kind of took from
Okay, I think those are excellent points. So what else do you guys have?
Well, I looked at the fact. Are you hearing me well?
Yeah, go ahead, Lynn. Go ahead.
Great.
Go ahead.
Okay. So I was thinking that, life happens, and the idea of a tort is to ensure that wrongs are addressed. So there are some wrongs or some harms to me that occur just because life is not perfect. And I was looking at this case, Roe versus the Minister of Health, where the hospital basically had no way of knowing that there were these little vials and they had become contaminated. They kept them in the same condition that they usually did. But unfortunately, there was a crack in one of the vials and it was infected, and someone basically died as a result of a hairline crack. So like everything was in place. There was no intended wrong, but there was a wrong that occurred. So I'm thinking that there is a necessity for tort because there was no intention there. And these things still have to be addressed.
So it sounds like that's a lot of the same point that Kayla was making, and I think you guys are making a fair point. Let me ask you this: this is sort of open to everyone. This isn't just directed at Lynn. Do we think that the change in the standard of proof, moving from tort to criminal law, justifies the trade-off, or doesn't justify the trade-off, I suppose, is also possible. So let me rephrase and sort of explain it a little bit differently, right? We know that in criminal law, the burden of proof, the standard that the state has to meet, is they have to prove their case beyond a reasonable doubt. And in tort law, the standard that the plaintiff must meet is the balance of probabilities, right? More likely than not, sometimes you've seen it referred to as a 51% probability, and I don't like that phrasing for reasons that we don't have time to go into. But the point being that it's a much lower standard of proof, right? So there's a lot of cases where you can prove tort liability to the balance of the probabilities, but you can't prove criminal liability beyond a reasonable doubt. And so your injured parties in all of those cases would just be left out. So does that seem, is that a trade-off that's worth making? Go ahead, Lynn.
Well, I actually kind of thought about that too, because I was thinking about the O.J. Simpson case, and I was thinking that maybe even though he was not indicted for murder, the civil case may have probably made the family feel a little bit more like they got some sort of justice.
Well, he was indicted, right? They had a whole trial. It was a couple of years long, and he wasn't convicted. But but other than that one small slip in the terminology, everything you said seems correct to me, right? So I think that's right. So
Sir?
Yes, go ahead, Kayla.
Sorry, not to cross you, but just a quick question. Do you think that tort law is just like a backbone for criminal law? Just in case, like, okay, if this does not actually work, I can still charge you under this?
No, not at all. For one thing, there's any number of tortious things that aren't crimes at all. And there are crimes that aren't torts, right? They're what are called so-called victimless crimes, right? So those are all crimes for which no tortious liability could be imposed under any circumstances. And then there's plenty of times where you commit a tort, but there's not a crime that lies underneath it because the crime would require some sort of mens rea element, or the conduct just hasn't been criminalized, but it violates the duty of care, right? Any number of possibilities. So I don't see them as interchangeable. But the purpose of the question is for you guys to think about whether you see them as interchangeable, not for me to think about it. I've done that thinking. I've been in this game a while. So does that make sense? Does that answer your question, Kayla? Good. Okay. we're almost out of time, so let's start wrapping things up. Let me check in and ask, does anyone else want to offer up what they came up with in reviewing the tutorial question for this week?
Can you please ask the question again? I missed what you said.
Sure. I'm just checking in to see if anybody else who hasn't already participated wants to jump in and offer up their thoughts on the proposition.
Sir?
Yes, go ahead, Danica.
So I was thinking that, so the question is, the statement you put in was contract and criminal liability sufficiently deter negligent conduct, right? But then we are looking at it now. So we are saying that we almost like need tort. So I was thinking that it is different from, it would help with individual cases because, you know, tort deals with the individual person that was harmed, whereas criminal and contract deal with like against the state or companies and so on. So I was saying that we do need it because if not, the individual person wouldn't get as much justice in that sense. So I was thinking that, but I'm not sure.
So the only thing in there that I would disagree with is the characterization that contract law involves companies, right? Contract law involves everyone, but the key feature of contract law is that it involves relationships, right? So there's a private law theorist that I've read who refers to the three areas of private law as contracts involve relationships, torts involve events, and property involves objects, right? And so those are sort of the key differences between the three private law areas. And obviously criminal law is part of this conversation, but that's not a private law subject. So other than that, I think everything you said is correct, that when it comes to whose interests are being vindicated, that criminal law is about vindicating the interests of the state, whereas tort law is about vindicating the interests of the injured party. And that is a trade-off that we make, right? And if we moved all tort cases into the criminal sphere, that would be a trade-off that we would have to accept, and we'd have to figure out whether and how we would want to mitigate that. Okay. So
It's understood, sir.
Yeah, no problem. Last question sent to me privately. Assuming that we get rid of tort, wouldn't it be more difficult to convict someone of that lesser crime since it turns into criminal liability? I will answer this very briefly because we're out of time, but I think that as I understand this question, and I may not be understanding it correctly, there's a presumption in the question that there's a perfect overlap between torts and criminal law. And as I've said, that's not the case, right? But absolutely, right, cases where you would impose tort liability for anything between the balance of probabilities and beyond a reasonable doubt, if we move that into criminal law, you would no longer be able to impose liability. Okay? So guys, I really appreciate y'all coming in and showing up and showing out. You guys, I haven't said this to everyone, but so you guys will hear it again when I say it in a lecture, but the engagement and the preparation that I get from you guys is really appreciated and is you guys are a good example for your classmates, and I appreciate that. So I will see you guys on Monday, and take care, and bye.